The last of the cases that we'll talk about on the technology side today is actually a client that I represented, and kind of an interesting case, I'd say, on many fronts. One of the most interesting things I found is really that the client even got into the objection or appeal stage. So the facts of the case were that the client had actually come to me through filing the claims on their own because they'd had 12 years of successful claims. And at which point I looked at the objections that were coming through, and many of the objections at the time I agreed with CRA's position. But this was one of the ones where I thought, I don't wholeheartedly agree with the CRA's position, and perhaps I should help represent this client and take them through the tax court process. So I've been actually a little bit surprised at many of the things that I've learned as we've gone through and the experiences that I've had. So what the client was trying to do here is a little bit of a source of confusion, I believe, both at the court side and led perhaps to a bit of the negative result. What had originally happened was the client had done work, and as we said, had successful claims for 11 or 12 years, 100% accepted, up until the point where this claim was 100% denied. And this has happened to a lot of taxpayers in started around the 2009 period. And of course, he didn't understand why, that it was business as usual, and he'd always written his reports as he had. And what we explained was that the CRA had, more or less begun tightening the constraints or its review processes, and maybe we need to provide a little additional information. So effectively, his projects broke down into two main categories, I would call them. They were the formulation type projects, which represented about 80% of the cost, which were 6 projects looking at different formulations for 6 distinct products. And basically, the other project or activity, I would call it, was a bottling process where they were trying to use a hot and cold bottling system to help meet some of the objectives on the other development products. The original project was submitted as a single project, and really what happened was when we started helping the client document, we moved it to look at some of the projects individually, how they would stand on their own, and then how the bottling process was a supporting activity. Now, I think what happened is that numerous things got confused in the court case itself, and I'll talk about that in a bit, but it wasn't really because of the science. I would attribute a lot of the confusion to the administration of the court process itself, and maybe a lack of understanding of the requirements, both on my part and perhaps on the claimant, as well as maybe a lack of leniency in many cases on the part of the court, and we'll talk about the specifics of that. But what had happened here is the client, being an expert in the field, has a Bachelor of Science from the University of Waterloo. He had 30 years of experience in developing his particular products. And one of the development products that we were looking at was called a sterile shot, which was basically a medicinal drink. Effectively, what the client had found through his personal use is that he was diabetic and on statin drugs, and that there was a medical consensus that if you had a high degree of plant sterols in your diet, eating a lot of green vegetables, let's say, it could bring that statin count down. And effectively, it's often hard to eat that degree of green vegetables every day. So what he wanted to do was to take a patent that had more or less figured out how to put the sterols into orange juice, and they could get this his desired degree of concentration of 80 milligrams in 16 ounces of orange juice, which he was using as a supplement. He thought that he could, through experimentation, bring that down to a concentration of 2 ounces to have an energy shot like you would buy at a corner store. Now, there were numerous problems in achieving this. basically from the fact that plant sterols are a very tough, fibrous material. They don't dissolve or easily in water, and even if you can break them and get them to dissolve in water, they tend to sediment out. And basically for the device or the product in question, you could have the client shake it, but you didn't want a huge amount of sedimentation. You needed the product to be uniformly mixed. So the whole question became, could we develop a process and a technology to develop this, and in fact, increase the concentration of plant sterols above any product that had ever been developed before. And in this respect, the client claims to have looked at over 70 articles and issues and patents and dealt with experts along the way, but it was numerous years before the case was even challenged. And very often, taxpayers don't keep all of those things, especially someone who's within the field and reading all the time, constantly on something. So what the client did was they referred to one particular patent that they thought was indicative of the technology at the time. And this was a patent by a company named Cargill. That talked about the issue of solubility of these plant sterols and some of the problems. So, the patent itself, on reading into it or through it, talks about the incorporation of plant sterols has been a challenge due to their hydrophobic nature. It talks about literature of incorporating them into water, why it's problematic, the cost of chemical modifications, safety concerns, the use of inorganic solvents, stability issues, flocculation, textural flavor properties, all of which, again, were cited by my client in his development as using this as a starting point. The patent also, in my opinion, gave a very good outline of some of the variables, the temperatures that were needed, the steps in the process where a change in one or another change of the process itself, its parameters or its ingredients, could have unpredictable upstream or downstream effects. So the client, as part of his evidence, analyzed the Cargill patent and talked about why it was different, that it was used as a spray that went into a powder, and that the powder was then dispersed into the orange juice or ingredients or whatever they were looking for. That it used a high shear mix with a emulsifying that they chose to eliminate the use of the powder, spray dried powder, to increase the concentrations and to decrease the sedimentation rates over the patented or known process through a variety of techniques. Now, it was at this point where I felt fairly confident that the client had fairly strong evidence of both standard practice, that they were skilled in the art, that their evidence themselves, when we looked at what they did and the support of their research, they were able to provide a fair amount of documentation as to the research steps themselves and what was actually done in the project. So again, we had handwritten notes, we had test results, we had all the various factors going in. It seemed things were done systematically and that the factors were identified. However, it became interesting at this point that the client was ultimately challenged really on the basis of the 5 questions in the SR&ED guidelines or fundamentals that they talk about as the Northwest Hydraulics case. And what I'd like to do is talk about really what happened in the judgment and go through this case in a little more detail. But before I do that, I'm going to jump and look at one other case here.